Hi everyone. Today I'm here with my teammates to give you a talk on the law on sexual offences in Malaysia. I'll be first discussing on the most serious crime under sexual offence, which is rape under section 375 of the Penal Code. Rape is a serious crime according to the Malaysian Penal Code and could be punished with imprisonment up to 30 years according to the latest amendment in 2014. According to section 375 of the Penal Code, rape is unlawful sexual intercourse between a man and a woman without the latter's consent and against her will. Now, I will briefly discuss on the description under subsection A to G of section 375. The first and second circumstance will be against her will and without her consent under A and B. In UP and Shorty law, against her will indicates the woman resisted and there was opposition, whereas without her consent means she decided not to accept and there was no resistance to it. Consent is irrelevant under fear of misconception, unsoundness of mind, and children under 12 years old. In Teo Eng Chan, there was clearly no consent from the victim, but she went on saying honest belief in consent is not good enough and there must be reasonable belief. Under subsection C, consent is irrelevant if obtained by putting the woman in fear of death or hurt under misconception of fact and known to the man. For example, a man threatens to kill a woman if she refuses to have sex with him. The man knows she consented to sex out of fear he purposely caused. Court found no consent in Maharashtra and Prakash because consent is gained when the victim is fearful. In Aling bin Ayun, the victim was treated with an axe, there was no consent and he was in fear of death and injury. Another case of Tai Hui Hyong, accused tells the victim that she would die in March if she does not have sexual intercourse with him. This clearly showed that the consent is obtained out of fear. Example of misconception of fact is that a married man persuaded a woman to have sexual intercourse with him by pretending to be a single. The man consciously gave the woman information that led her to consent to something she might not have otherwise. Now I'll pass it to Clement to explain subsection D until subsection G.
Thank you, Claire. Moving on to subsection D, consent is irrelevant as a woman believes the man is whom she believes herself will be lawfully married, while in fact the man knows he is not her husband. For example, a woman consented to have sex with a man because she believed he is her husband, but the person is impersonating her lawful husband who may be identical twins, to advantage of her belief. Under subsection E, consent is irrelevant as a woman cannot understand the nature and consequence of what she consented. For example, strong medications makes a woman unable to think clearly and makes her consent to be something without fully understand it. A man who is aware takes advantage by asking the girl to have sex with him, but her consent is invalid because she cannot understand her own decisions. Under subsection F, the consent is being obtained with the positions of authority over the woman. An employer asks an employee to have sex with him, and the woman agrees out of fear of losing her job. She consents because of her employer's authority. The final circumstance is a woman under 16 years of age. In Yak Hossain, rape is being conducted as a children is only at the age of 12. Under section 375 provides several sexual intercourse explanations, which I will simplify. Therefore, what constitutes sexual intercourse? Penetration is sufficient to constitute sexual intercourse with the penis, as in the case of Nazaro ruling indicates penetration cannot be proven because it did not show the penetration is with penis. Sidat bin Ludan proved that even slight penetration is adequate, and Ahmad Najib showed that the requirement of penetration with the presence of semen if the man has sexual intercourse with his wife under any written law in force, it is not rape.
Thank you, Claire, for such insightful information. Good day, students. I'm Jack Hee-jun, your second speaker. Within the discussion of rape, I will now cover a possible defense under the Penal Code, where nothing is an offense if done by someone justified by law, or who, due to a mistake of fact, in good faith believes they are justified by law, as this is outlined in section 79. This defense applies when a defendant, due to a genuine mistake of fact and acting in good faith, believes the victim consented. For instance, in the case Teo Eng Chan and others, the defendant claimed for such a belief. However, good faith defined in section 52 requires reasonable grounds. Negligence or reckless assumptions disqualify the defense, ensuring a balance between fairness and accountability. Next, let's examine the marital exception in section 375. While sexual intercourse within marriage is generally not considered rape if the wife is above a certain age, there are important exceptions. A husband can be charged with rape if the couple is under judicial separation, a decree-nisi has been issued, or the husband is under a court injunction. These conditions prioritize consent and personal boundaries within marriage. Beyond these exceptions, the Penal Code also addresses situations where harm or coercion is used within marriage. Under section 375A, any man who, while in a lawful marriage, inflicts pain, fear of death, or harm on his wife or another person to engage in sexual relations can face imprisonment for up to 5 years. This provision emphasizes that consent and safety must be respected even within a marital relationship. Extending these protections, the Penal Code addresses the grave offense of gang rape under section 375B, which occurs when a person is raped by multiple perpetrators acting together. A notable case took place in Kuala Kangsar, where 6 men, including 5 siblings, were charged in the Sessions Court with gang raping and sexually assaulting an 11-year-old girl. Unfortunately, this incident is not an isolated incident in our country. Acknowledging the severe trauma caused by such crimes, the law imposes harsh penalties, with offenders facing imprisonment of no less than 10 years and up to 30 years, ensuring justice for victims.
Thank you, Hee-jun, and good afternoon. I'm the next speaker, Kassim. Now, I'll be highlighting other sexual offenses for you all. Rape is already considered a serious offense, but the Penal Code further categorizes a more severe type of rape, known as aggravated rape, under Section 376, subsection 2. It includes cases where the offender causes harm, instills fear, commits the act in the presence of others, or abuses trust to gain consent. It also covers victim under 16 without consent, under 12 where consent is irrelevant, pregnant victims, and those who become insane due to the attack. Aggravated rape applies if the accused knows they have HIV, or if the victim commits suicide or has a mental, emotional, or physical condition known to the offender. To address the rise in incest cases, the government amended Penal Code in 2002, adding Section 376A and 376B. 376A defines incest as sexual intercourse between family members prohibited from marrying, while Section 376B prescribes 6 to 20 years of imprisonment and mandatory raping. In Ismail Rashid case, the court emphasized that sentencing should reflect society's strong disapproval, especially when young victims are involved. Additionally, sexual connection by object, which involves the insertion of any object or any part of the body except the penis into the vagina or anus of the other without consent, is an offense under Section 377CA. As shown in the case of Bunya Jolong, the introduction of a finger with semen into the vagina without consent was argued to be an offense under this section. It should be noted that this section does not extend to medical or law enforcement purposes. Thereupon, the insertion of object into the vagina or anus as an example in the course of medical procedure does not amount to an offense under Section 377CA. Next, the offense of outrageous or indecency is provided under Section 377D of the Penal Code. It states that anyone who commits, encourages, persuades, or tries to persuade the commission of any act of gross indecency with the other is committing an offense. This can be done in public or private. Interestingly, this section covers the person being penetrated. In Sukma Darmawan was alleged committing an offense under this section for allowing Anwar Ibrahim to insert the penis into his anus. However, this conviction was ultimately quashed due to the issue of voluntariness.
Thank you, Kassim. Hi everyone, I'm the next speaker, Jia Shen. I will continue with the other provisions of unnatural offense under the Penal Code. Besides the offense of outrageous on decency and sexual connection by object, carnal intercourse against the order of nature is also an unnatural offense under Section 377A. In this section, read together with its explanation, having sexual connection with others by penetration of penis into the anus or mouth is considered an offense. We can refer to the well-known case of Dato Seri Anwar bin Ibrahim, which involved a penetration of anus with penis. Do you know that this act can be an offense even if there is consent? Given the wide definition, it is an offense even for married couples to engage in consensual oral or anal sex within the four walls of their bedrooms. Also, in Singapore case, Public Prosecutor and Anis Abdullah, a police coast guard, was convicted under Section 377 of the Singapore Penal Code, which is in pari material with 377A and B of our Penal Code, for engaging in a consensual oral sex with an adult female person in private. The Penal Code has differentiated this offence by charging the accused under different sections in the case of a lack of consent. Section 377C specifically deals with the same type of offence, but without consent. In this provision, anyone who voluntarily commits the offence without the other's consent, or against the other's will, or in order to commit the offence, put the other in fear of death or hurt to the person himself or a third party, will be convicted. This includes a situation where the accused forced the victim to perform oral sex, and this was exactly what happened in the case of Chang Wan-chuan. Now, I will pass the mic back to Clement, who will delve into the justification part of the discussion. Thank you.
Now I'm going to demonstrate to you how the citizens in Malaysia are being protected by a law of sexual offences under the Penal Code. There is a recent case where 4 youths were charged at the Session Court with raping a 14-year-old girl on November 10, 2024 in the house in Jalan Sungai, Ara, Bayan Lepas. All 4 accused are adults as they were charged under Section 376 subsection 1 of the Penal Code, which carry a sentence up to 20 years imprisonment and can upon convictions as under the Penal Code. Consent is irrelevant for a victim under the age of 16 under Section 375 subsection G. In Selangor, a high percentage of sexual offences, including rape and molestation, was reported by the Criminal Investigation Department (CID) Chief Datuk Fazil that the involvement victims are aged between 14 to 18. The police utilised Section 375 and 376 of the Penal Code to prosecute this case, stated even if consent is given, the acts against a minor are still categorised as a rape, as minors below 16 cannot legally consent. This case shows that the law sufficiently protect the minors from sexual offences. Let me ask you, do you think there is sufficient protection of the law of sexual offences under the Penal Code? Malaysia's Penal Code provides a significant legal provisions to combat sexual offences, including law against rape in Section 375 and certain provisions under Section 376 and 377 as mentioned by my groupmates just now. This law imposes severe penalties such as long prison terms and fines, designed to deter offenders and ensure justice for victims. The inclusion of section addressing marital rape, Section 375A, and specific provision for gang rape further emphasize the comprehensive of the legislation. However, several challenges persist in the practical applications of these laws. One key issue in the lack of explicit legal provisions addressing male rape. While the Penal Code, male victims are often marginalized as the law does not recognize men as victims of rape, forcing such cases to be prosecuted under less severe charges like Section 354 and Section 509. Another issue in the ambiguity surrounding consent, particularly in situations involving coercion or intoxications. Courts have struggled to inconsistently interpret what constitutes free and informed consent, which may disadvantage victims during trials. Furthermore, the Penal Code focuses heavily on punitive measures without emphasizing victims' rehabilitations. These limitations, combined with societal stigma, hinders the law's effectiveness in addressing sexual offences. Therefore, while the Penal Code forms a strong foundation in gaps, reflects the need for reformations and inclusive in protecting all individuals.
Now I'll discuss the grey areas under Malaysian law on sexual offences. Male rape remains a hidden injustice in Malaysia as current law only defines rape as a man penetrating a woman without consent. Most of the cases involving male victims were investigated under Section 509 of the Penal Code, dealing with words or gestures intended to insult the modesty of a person. Criminologist and Enforcement Leadership and Management University, ELMU Vice-Chancellor Datuk Dr. Kasim Nur Mohamad is in the opinion that the lack of specific legal recourse for male rape victims has also led cases to be pigeonholed as sexual harassment or abuse or sodomy. Sodomy can also carry additional stigma on its own. He further stated that it is unequal to not allow for a woman to be charged with raping a man. The law must protect everyone regardless of gender, and many male survivors stay silent due to fear of ridicule or disbelief, further marginalizing them and perpetuating harmful stereotypes. It's time to expand our laws and recognize male rape as a crime, fostering a justice system that supports all survivors equally. Let's challenge the stigma, advocate for reform, and ensure dignity and justice for everyone. Thank you.
The second dissatisfaction concerns the issue of consent. As we know, rape is committed when there is no consent or when the consent is ethically invalid due to factors like coercion, misconception, or incapacity as discussed earlier. Thus, there is no issue with rape since Section 90 provides comprehensive protection in this regard. However, the existence of Section 377A is unconvincing. Why is a carnal intercourse involving the penetration of the mouth or anus with a penis still an offence even when there is consent? In comparison, under Section 1 of the UK's Sexual Offences Act 2003, the penetration of the mouth or anus by a penis constitutes rape only when there is a lack of consent. The law in Malaysia, by contrast, appears overly broad and restrictive as it interferes with the consensual activities between partners. Malaysia might consider the UK court's reasoning in Crown against Wilson, which held that the privacy of the matrimonial home is not a proper matter for criminal investigation. In Wilson, the case involved branding initials on a partner's buttock with a hot knife done with consent. Even if the issue of consent is irrelevant under Section 377A, why does the law tolerate a different standard under Section 377CA, where only non-consensual penetration by an object or part of the body excluding the penis into the vagina or anus is deemed an offence? Why did Parliament not include consensual sexual acts under this section? The distinction made by Parliament appears unclear and arbitrary as both situations pertain to similar subject matters. This inconsistency and ambiguity in the law regarding consent create a significant grey area.
Moving on, I will expand on Jashan's discussion of grey areas in sexual offences. First, let's talk about Section 375A, which criminalizes coercion by a husband. However, it does not recognize marital rape as a standalone offence. This means that, unless harm or fear is proven, a husband cannot be prosecuted for rape even without his wife's consent. Proving harm or fear is often challenging, especially when abuse happens in private and many victims face cultural stigma that prevents them from coming forward. The marital exception in Section 375 further implies that consent is automatically given in marriage, raising questions about autonomy and boundaries. Finally, let's address the challenges faced by transgender individuals. In Malaysia, those who undergo gender reassignment surgery must obtain a court declaration to legally change their gender. Until this happens, their legal gender remains the one assigned at birth. For example, if a transgender woman has non-consensual intercourse with a man, it wouldn't legally be considered rape unless the court has recognized her as female before the act. This creates confusion and highlights the need for clearer, more inclusive legal provisions. These examples highlight the need for reforms to make sexual offence laws more equitable and inclusive. As future leaders, your understanding and advocacy are crucial in shaping a legal system that protects everyone. Recognizing this grey area is the first step toward meaningful change. That's all from me. Now I'll hand it over to Kesing for the next part of discussion. Thank you.
The best way to prevent sexual offences is through primary prevention, which means stopping it before it happens. Public education should focus on teaching parents and children on sexual abuse, the signs and the symptoms, and how grooming works. The Ministry of Education should work with NGOs and healthcare professionals to appoint sexuality educators in schools. Additionally, the Ministry of Communications should restrict explicit content, block pornography sites, and promote positive media to encourage peace and empathy. I hope today's talk has given you a better understanding of the law on sexual offences in Malaysia. Remember, it's important to speak up and stick up to protect yourself and others. Thank you for your time. If you are experiencing sexual violence, please reach out for free and confidential support.